Point, I think, Victor Sherman, is that this is a judge who has been critical of the prosecutor at times about the way the search warrants have been executed, and has challenged them, has restricted certain pieces of evidence from coming in, etc. And yet he signed off on this warrant, so there must be a good reason, right?
Well, all he has to do is make a determination that's probable cause. He can't say whether it's a good tactical decision or not, or whether the prosecution has waited too long. He's not in the position of a defense attorney to make those decisions. If they present him with a search warrant and there's probable cause in the affidavit, then he has really no choice but to sign the warrant. And I think he's going to leave it up to the defense attorneys to
I agree with you on
make a
that,
motion that it was improper.
What's the reasoning, though? I mean, give me a hypothetical as to why the prosecutors might have needed until now to get a DNA swab from Michael Jackson seems like the most obvious piece of evidence you need.
Well, you would think that, and it sounds to me like maybe more important was in the preparation for trial, they realized the defense was going to bring up certain defenses, like, for instance, the sight lines or what the dimensions of the various rooms were. So this seems to me maybe more important than the swabs. That is what the dimensions of these various rooms that they're going to present at trial, because apparently they had various experts at the ranch that they're going to use to make demonstrative evidence. So that may have been the most important reason. What I wonder was why they just didn't make a motion in court. Why do they have to traumatize the Jackson family by a search when they could have made a motion in court to get permission to do these same things without the necessity of this this type of activity that's intended to intimidate?
Yeah.
That's what I don't understand.
Jim?
We're going to see some of the kids. We've got this Wade Robeson. We've got his mother. I think there's the boy from Australia is going to come in. All these people may come in and say he didn't molest me, but that does not necessarily clear the question of the conspiracy.
Well, it may not necessarily clear the question of the conspiracy, but it certainly puts a major dent in it because various witnesses say, for instance, Macaulay McCulkin, that he was there and there was the inference that there was molestation going on between Jackson and that particular individual. Now, if he comes on the stand and says nothing happened, then that undermines the witnesses that already have testified and puts a major hole in the conspiracy. And if Michael has a number of other witnesses come and support his theory and his thinking that, well, I liked a lot of boys around, they slept in my bed, but I never molested them, I never touched them, and these people now support Michael Jackson's story, then you're creating reasonable doubt. And that's all Tom Mesereau wants to do, is create reasonable doubt. By the way, I would like to, I think you should have the rabbi on every day. I think he's a very entertaining individual. And the concept that it's a good idea to send someone to jail because that's a good way for rehabilitating that person.
What sort of relationship is protected there? Could they get a search warrant and waltz in under some sort of conspiracy theory? What would they be doing with the investigator's office?
Well, I don't know specifically in this case, but the only privilege an investigator would have is if he was hired by an attorney on behalf of Mr. Jackson, then it would become under the attorney-client privilege. Otherwise, there would be no privilege. On the other hand, if a client and the investigator, or for that matter, a client and an attorney, are involved in criminal activity of any kind, then it's not protected by the attorney-client privilege under any circumstance. So it would depend upon the arrangement between Mr. Jackson and the investigator, whether or not the investigator was working on his own directly with Mr. Jackson or under the auspices of an attorney, then the attorney-client privilege could apply. Okay, but they could have done it. Why didn't they just make a motion in the court and say to the judge, hey, we need to go out, we want to make some demonstrative evidence, give the defense notice. It's not like they were going to demolish the house or anything. Why go to this?
But if there was, I don't know, but the answer is if there'd been another way to do it, maybe the judge would have said, look, why don't you just make a motion in court as opposed to going to the house? Because, you know, a search warrant is something that isn't supposed to be the first option. That's something the judge, I'm sure, considered, but who knows?
Tell me about Mark Garagos. Every impression, I've interviewed the man, we've all watched him in many cases. It's my impression this guy wouldn't tolerate this sort of behavior. I find it shocking, but do you stay on a case like this? Or maybe is that why he brought in Ben Brafman, so he could maybe go work on Scott Peterson and kind of distance himself?
Well, I'm not sure. Do you know that he brought in Ben Brafman, or Ben Brafman was brought in by other people? I would suspect more the latter. Good distinction. Rather than Mark bringing in Mr. Brafman, who, by the way, obviously is a very close friend of Johnny Cochran's, and Johnny Cochran going back to the '93 incident. I would suspect that behind this whole bringing in a new attorney was probably the hand of Johnny Cochran. That would be my guess. I don't have any information about that, but that's what I think. And I have talked to friends of mine that are attorneys in New York, and that's what they think. I think it's good for Mark, however, to bring in Mr. Brafman. First of all, he's an excellent attorney. And I think that Mark, because of his workload, needs another attorney to help him on this particular case and also to share the responsibility. I mean, Michael Jackson is such an enormous client in such an important case that to do it by himself, I think, is foolhardy. So I think he's lucky.
What happened? Not do you like these people, but do you believe that any sort of molestation occurred?
Well, I think it's to Tom Mesereau's benefit that the jury may not like these women, these mothers, or maybe even Debbie Rowe, even though she said nice things about Michael. So I'm not sure why he would want to bring the action away from the women and toward Michael. If anything, Tom Mesereau probably would like to minimize the jury looking at Michael's behavior and rather looking at the behavior of these various women and show that they're not reliable. And if the prosecution is depending upon the credibility of these women to convict Michael Jackson, that they're not credible because either, as the rabbi said, they're not worthy of believing because of their past conduct. So I would pose the question differently than the way you put it.